Ladies and gents, welcome back. There was a recent decision made in Alberta. This is a court case that's quite complicated for me, and it's really hard for me to describe exactly what's going on here, but it has to do with restrictions that were put in place in Alberta under Dr. Hinshaw's orders. And, well, they've been deemed unlawful. Is that what the case is today? I've brought in Keith Wilson to tell me exactly what it is that they're actually talking about. So welcome to the show, Keith.
Good to be here, Clyde. Good to see you.
Yeah. When I have tough legal questions, I always call on you because you're the guy who's got the answers for me. And this one is really confusing. So was it that what the restrictions they put on in Alberta under Hinshaw during the COVID pandemic, was it deemed illegal what they did, or how is this worded?
Yeah, they were deemed illegal. So our Court of King's Bench had a case brought before it where some Albertans who were churchgoers, others who ran businesses, others who were just normal family people who were upset that the government was telling them that they couldn't have gatherings in their home at Christmas, that they couldn't go to church, that they couldn't go to the gym, businesses couldn't have people come to their restaurant and workplaces and so on. They felt that that was a step too far, and they brought a legal challenge alleging that the public health orders in Alberta by the Chief Medical Officer of Health, Dr. Hinshaw, that were brought in 2020 and in place up until 2021 that shut down all these businesses and gyms and places of assembly and restrict recreation activities and skating on a outdoor rink and all those things, that they were unlawful, they exceeded the jurisdiction of the Public Health Act, and that they were unconstitutional and they breached the Charter and as well as the Alberta Bill of Rights. And
we're talking about the Canadian Charter of Rights here.
Well, there's the Canadian Charter of Rights that applies all across Canada, and then there's the federal Bill of Rights, the Canadian Bill of Rights that applies to federal jurisdiction and decision making. And then most provinces, including Alberta, have their own Bill of Rights. Not all, but Alberta, in fact, has one. It's called the Alberta Bill of Rights. So it was alleged that it was a breach of the Charter, which is the supreme law of Canada, supposed to be. That's what I was told at law school, getting highly skeptical of that. And then the Alberta Bill of Rights. And so the court released its 70 or 80 page decision on Monday.
So what does this mean moving forward? Like, it's deemed that what they did was illegal, so we just throw in the towel and nothing happens? Or is there any sort of repercussions now that the government put citizens through all of this and now we're just left kind of holding the bag?
Well, and many people lost their businesses. You know, a lot of gyms closed. A lot of people even lost their homes because they used their house as their collateral for their long-term lease for their restaurant that got shut down. You know, a lot of people lost their jobs, their livelihoods, in addition to all the social harm that was caused by not being able to go to the hockey rink or to the gym, or people and kids to engage in their sports, whether it be lacrosse or volleyball or basketball or other important events, and funerals and weddings and anniversaries and reunions. I could keep going. So It was just a disastrous time for government overreach, in my view. But what did the court rule? Like, let's break that down. So they ruled that the health orders were ultra vires. So that's Latin. It means beyond the jurisdiction, unlawful. And the reason they did is kind of interesting. The Public Health Act says only one person gets to decide whether or not to impose these restrictions on Albertans or classes of Albertans and businesses and individuals and take away their rights. And that is the Chief Medical Officer of Health. But what she testified she did, she went and met with the provincial cabinet, Jason Kenney's cabinet, and they actually decided to close the businesses, to close the skating rinks, to close the churches, to force people not to have any visitors in their homes and so on. And well, is that legal? If the public health medical or the chief medical officer of health was supposed to decide and someone else decides, in administrative law, in the area of law called administrative law, which is dealing with review of government decisions, we call that either an improper subdelegation or fettering discretion. Well, what the heck does that mean? You've got a mechanic's license, right, Clyde?
Yeah, that's right.
Right. So there'll be legislation in British Columbia that says some superintendent or minister or deputy minister of industry or
Yeah,
something.
the industry training authority we have, yeah.
There you go. I'm just using an example. Is specifically authorized to decide on your application and to whether or not you're going to be a mechanic. So let's say that person, for some reason, asked his neighbor to do it. Said, here, you decide on whether Clyde can become a mechanic. And then it turns out he says no. And you find out about that. You go, wait a minute. You can't just let this guy's neighbor. Only he's authorized to decide. So it's a really technical ruling. So the court ruled that the health orders were invalid, unlawful, illegal, ultra vires, because Hinshaw and only Hinshaw was the one authorized to make that decision. And she improperly subdelegated. She fettered her discretion by getting someone else to decide, which was the cabinet.
So it's a technicality. They're ruling this all on a technicality.
Yeah, that's unfortunately. Now it's significant because they're struck down. Mm-hmm. They're declared and they get struck in their first instance. They're void ab initio. A lot of Latin phrases here. Void in their first instance. You cannot. You have jurisdiction to do something as a government official against people. And if at some point in the exercise of that it's struck down in its first instance. In other words, if you screwed up, it's done. Doesn't work. No good. Start over, right? Mm-hmm. So that means at no time were these things lawful, and businesses were closed. And what does that mean? Well, they also, and I'll answer that. What does that mean in a second? Mm-hmm. But also looked at the charter and the Alberta Bill of Rights. And the court ruled that there was a breach of freedom of religion under Section 2, as well as freedom of association and freedom of assembly under Section 2 of the charter as well. But the court went on to apply the Oakes test and invoke Section 1 of the charter, which says, the court said that the restrictions were reasonably justified in a free and demonstrably justified in a free and democratic society. I don't agree with the analysis. I thought it was highly tilted too far one way. So it begs the question, what does this mean? Whether it was a technicality, whether or not the public health orders that affected millions of Albertans, or all Albertans, mm-hmm. not millions, all 4.8 million Albertans, in a very dramatic, historically oppressive, overreaching way, in my view, mm-hmm. they're struck down. Whether they're struck down at the end of the day under the charter, or whether it was an ultra vires acts of improper subdelegation or fettering discretion, doesn't really matter. They're struck down. Okay, well, what practical consequence does that have? And one of the things I looked at is, I believe it's Section 66 might be 68 of the Public Health Act, says that as long as public health officials were acting in good faith, you can't sue them for any damages that you suffer. Now, there's still an open question, and I haven't had a chance to fully research it, whether or not the fact that it was the cabinet that actually made the decision, you can somehow get around that statutory immunity provision. There might be a possibility there. I've got to look into it more closely. Mm-hmm. So there is a possibility that those who were financially harmed by this, may be able to bring a claim against the government. They'll have to act within 2 years of receiving of the harm occurring to them by the illegal act, which has now been confirmed to have been illegal.
But now we're getting on in time at this point, where they're almost running out of time at the point when they'll
have to move quickly for sure.
That's it. Yeah.
Yeah. And there's another aspect too of this, which is, so that'll have to be looked at. And we have this decision. It's good that a court is still applying the rule of law. I guess that would be the silver lining in it, that they're applying the rule of law and saying, yeah, you gotta, when these types of powers are exercised, they have to be exercised properly. And that's good. I think it should also cause the government here under Premier Danielle Smith to review the act, because I don't think decisions that are this far reaching should be made by a single technocratic government
Just one
official.
person. Yeah,
Yeah,
that's
like if the only criteria is health, why doesn't the chief medical officer of health ban cars? Because there's car accidents, right?
yes, yes.
Like if there's no
It's
cars,
causing all
and
kinds of damage
what about motorcycles? Like shouldn't, like no, and the reason we don't let that happen
because
is
it's
there's a
ridiculous.
balancing. And that's been one of the criticisms of people who are upset about what the government did, was there was no balancing, right?
Mhm.
There was no balancing of so we're going to do this incredible harm to our children and their schooling and their social development when they're at super low risk. So we're going to lock up the healthy to protect the ill. Like we've never done that before. So I think this should be a reason for the provincial government here in Alberta to review the legislation so that it's absolutely clear that it should only be the cabinet and emergency management type officials making the decision, and not a bureaucrat that has this narrow lens of only looking at the world through one perspective.
Not only that, it should have some sort of immediate repercussion where it goes into a referendum type situation where people decide afterwards, how are we going to move forward? You're making a unilateral decision in the immediate time, but as soon as everybody can gather, there should be a community decision behind some of these things. I don't think you should be able to rule with this kind of diktats in society, especially in a free, fair, and open society, which we're supposed to be in Canada and all across Canada, of course. Now, Keith, is this a win? And that's the big question of the day on this ruling. Is this actually a win, or is this just more par for the course?
There's aspects of it that are a win for sure. And I think the biggest aspect is because the rule of law was followed. And it's a contentious decision. It was a difficult decision for the court to make. I would have been happier if they would have ruled that the charter was breached and it wasn't saved by Section 1. But it is a win in that respect. It's a win in that it becomes a justification and a prompting for government to review the legislation and how it made its decisions. I think at a minimum, further to your point, that if this decision is going to be made by a minister or the cabinet, it should have to either, if it's going to be made there, it should immediately, like within 10 days or 5 days, have to be debated in the legislature.
Reviewed, yes.
Right, where we can all see it, because the cabinet room's secret. The cabinet room is secret. That's going to remain that way. That's part of our parliamentary tradition. So, I think that kind of a check and balance, or maybe these decisions should be made, with that they can make it and it's only good for 3 days, and then they got to go into the legislature. Like this whole thing.
Not
as
a
we
year
all
and a
know,
half as we went through, over a year and a half.
Well, it's never been debated in the legislature.
That's true. That's true. Keith
Never.
Wilson,
so
where can people find you? You haven't been so prominent on social media these days. You've been kind of hiding out, but where can people find you to see your opinions on these legal cases?
Sure. I guess the best way would be on Twitter. My Twitter handle is @IKWilson, @IKWilson, with one L. That's where I tend to provide information about legal stuff and other political topics that are of interest to me. And I've been very busy since the convoy and the public inquiry, rebuilding my law practice. It was a big hit. Doing all that work at either for free or at significantly reduced rates. And so I've been really busy with my more traditional client base, but I'm still out keeping an eye on things, and I'm happy to pop on from time to time with your show, Clyde, and talk about these things.
Well, thank you so much for joining me again.
Thank you.